All right, welcome to Kirk's Law Corner. I'm going to teach you a little bit about the right to petition, the history behind that, and how this all is supposed to work according to the letter of the law. And then I'm actually going to go into some criminal complaints, how we do that, how to be effective in taking this stuff down. Let's see. All right, this is a very good website to go use. It's a tool. This is law.cornell.edu. When you get there, you'll want to go get the law. I go directly to the Constitution. And when you go there, it brings up, the Constitution. You have to work your way through what you're looking for. As you can see how far down I had to get to that. Here's your Constitution, our Constitution. All of this where it says see explanation, this takes you to what's called the annotated Constitution. So like down here, First Amendment, see explanation. This is where I went. Then it takes you here, you got to do it again. See explanation. And then it gives you all of the breakdowns. What part you want to look at, what you want to read from. So we're going to look at the right of assembly and petition. A lot of people are not aware that the right of peaceably assemble has to do with calling them in to assemble peacefully so that we can redress our grievances. It does not have anything to do with going to church, standing picketing on the corner, and protest is actually a formal written declaration. A petition. Declaring something unlawful is about to happen or something unlawful has happened. That is a protest. When people stand on a corner, that's called picketing with signs. So words have meanings. And of course, they're not going to teach you the proper definitions of these words, but it's up to us to do our due diligence to know what these words actually mean. So here's the background and development according to the annotated Constitution. The right of petition took its rise from the modest provisions made for it in Chapter 61 of the Magna Carta. Okay, this goes clear back to 1215. And it actually goes a little further back than that, 1166 with the Aziz of Clarendon. To this meager beginning are the traceable in some measure Parliament itself and its procedures for the enactment of legislation, the equity jurisdiction of the Lord Chancellor, and proceedings against the Crown by petition of right. Thus, while the King summoned Parliament for the purpose of supply the latter, but especially the House of Commons, petitioned the King for a redress of grievances as its price for meeting the financial needs of the monarch, and as it increased in importance, it came to claim the right to dictate the form of the King's reply. Until 1414, Commons declared itself to be, as well as ancestors, as assenters, as petitioners. 250 years later, in 1669, Commons further resolved that every commoner in England possessed the inherent right to prepare and present petitions. This is an individual right. We do not have to have 100,000 signatures or 1,000,000 signatures to petition. In case of grievance, and a Commons to receive the same and to judge whether they were fit to be received. Finally, Chapter 5 of the Bill of Rights of 1689, that would be the English Bill of Rights, asserted the right of the subjects to petition the King and all commitments and prosecution for such petitioning to be illegal. Now, what was going on is the people were petitioning the King, and the King would send his men, an armed body of men, to come harass the people because, how dare you challenge the King's authority? Well, as you can see if you've read through history, we got tired of that crap, which is why we fled from there starting with Jamestown, Virginia of 1609 and the first charter of Virginia of 1606. Most people are not aware of the truth of our immigration from England, Great Britain to America. A lot of history starts with 1495, Christopher Columbus, and then the Mayflower. No. Try again. What was it? Six states that became states were originally 6 colonies within the territory of Virginia. They were all made out of the territory of Virginia. But I want to go off on a tangent here, but let's get back to the petition part. Asserted the right of the subjects to petition the king. Now, subjects, see, they try to say that we're subjects again. No, we're not subjects. We're man. To petition the king, and all commitments and prosecutions for such petitioning to be illegal. So, historically, therefore, the right of petition is the primary right. The right peaceably to assemble and subordinate, and an instrumental right, as if the First Amendment read, the right of the people peaceably to assemble in order to petition the government. So, notice how they leave those certain things out. But back then, this stuff was self-evident. Everybody knew about this in 1776, 1787, 1789. Today, however, the right to peaceably assemble is, in the language of the court, cognate to those of free speech and free press, and is equally fundamental. But see, but that's in the language of the court. But see, in our form of government, the judicial branch doesn't have the power to make law. So, this would be fundamentally altering our form of government. As one cannot be denied without violating those fundamental principles of liberty and justice which lie at the base of all civil and political institutions. Principles which the 14th Amendment, screw the 14th Amendment, that's a fraud. Embodies in the general terms of a due process clause. Really? Could have swore the 5th Amendment does due process of law. Not only that, due process of law comes from the common law, does not come from statutory law. Doesn't even come from the Constitution. So, not only that, we're talking parliamentary practice here, which comes from the common law. And I'm not talking necessarily the English common law, but it does, because it goes back to 1215. But we have what's called the American common law. While we may have adopted certain parts of the English common law when we came over here in 1603, 1606, there were certain parts that our original founders did not want. It was part of that Roman Catholic Church, Catholicism, which is nothing but Islam in disguise, going clear back to 400 BC. So, the right to free speech also had to do with petitioning. We even have it in the Constitution here, where it's like, anything that's said while in assembly, in the court of justice, which is the legislature, that's where we establish justice and that we ensure justice. Courts of law, in law, are the judicial branch. That's Article 3, Section 2. And the freedom of press, of course, that's right to publish, to speak on anything. But originally, the right to freedom of speech went with the right to petition and to speak freely in front of the assembly, peacefully. So there's your brief overview of the right. Now we have to look at the book, the tool that we use for this is this particular book right here. Okay. Come on. This is the law and practice of the legislative assemblies. Or should say Lex Parliamentary. I don't know. There we go. Lex Parliamentary Americana. elements of the law and practice of legislative assemblies in the United States of America. This might be a handy book to read. And it is. Because, now before I go over here to Mason's Manual of Legislative Procedure, okay, I'm not sure how many people are aware of this one, but I'm going to show you right now. And this is how I discovered this, was because we have a set of rules of procedure here. Not many people are aware of this, and I'll admit, 4.5 years ago, I'm like, what the heck is, what? There's rules of procedure? Yes. You have Senate rules, you have House rules. Now, some states have joint rules, which Idaho does. Some have general rules. But if you go into your rules of procedure for the legislature, and I use Control F for find, and I just do Mason. There it is, Rule 75 of the House Rules, Rules of Parliamentary Practice, set forth in Mason's Manual of Legislative Procedures shall govern the House in all cases to which they are applicable, and in which they are not inconsistent with the standard rules and orders of the House and the joint rules and orders of the Senate and the House of Representatives. Well, the problem is there shall be no rulemaking that would abrogate a right. So actually, Mason's Manual comes first. These are all made up by the set of men. But to a certain extent, we do have the right to choose how we practice, parliamentary practice, in the legislature, as in the rules of procedure that are supposed to govern the proceedings. Now, I'm also going to show you real quick while we're right here. I can get that. Look at that. Rule 12, petitions, memorials, etc. Petitions, memorials, and other papers addressed to the House shall be presented by the Speaker. Okay. That deprives a fundamental right, and that rulemaking abrogates the right. Miranda versus Arizona. I'm going to show you here in just a few minutes about the right to petition. Order of business. After calling the House to order, the order of business for the day. This is daily, folks. Roll call, all these fancy little steps. What's this? Step 14, presentation of petitions and communications. Okay, that was it. The Senate rules, same thing, says Mason's Manual. So just to give you an idea there, that's what you'll need to look. About 70% of the states use Mason's Manual legislative procedure. Some use Jefferson's. Now here's our Declaration of Rights here in Idaho. Right of assembly. Notice that to petition the legislature for the redress of grievances is under the right of assembly, because this is subject matter jurisdiction. The people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives, and to petition the legislature for the redress of grievances. So what this actually reads is, we have the right to petition the legislature for the redress of grievances, and we have the right to call them in to assemble, sit down, shut up, because we're here to consult for our common good, and we're here to instruct you to discharge the duties of your office, and to alter, reform, or abolish anything at any time we deem it necessary. This is how this right works. Rights are the law. So political power inherent in the people, all of it, not some of it, not most of it, but all of it, is inherent in the people. Government is instituted. This is the document that institutes government. So government is a piece of paper. Once you learn this and know this knowledge, this power, they're easily defeatable. So if government is instituted for our equal protection and benefit, and they have the right to alter, reform, or abolish the same whenever they may deem it necessary. Now here's another key. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. So when we're dealing with these corporations and businesses out here, it is a privilege to do business in our communities. So when a business has a business practice, a policy that just so happens to come in conflict with the law, our rights, like it says here, Article 11, corporations, public and private. First, they have to be bound by the Constitution. Second, the reason why we require them, and remember, this is us requiring them, public, all those in the public, in law. The people are in the private. Public meaning public servants. So anyone who is acting in interstate or foreign commerce, who has their doors open to the public, that is an invitation to come in. And while they do retain the right to refuse service for any reason, they have to articulate the reason. And not wearing a mask, this right here totally destroys that. The right of eminent domain police power. We'll get down here. The same. Oh, wait. And the police powers of the state shall never be abridged or so construed as to permit corporations to conduct their business in such manner as to infringe the equal rights of individuals or the general well-being of the state. In layman's terms, that means none of your business, none of your policy, your bylaws, can come in conflict with our rights, because our rights are the law. That was laid down first, long before we even instituted government. So, American Jurisprudence, Volume 16, Constitutional Law, Section 100, Bills of Rights and those merely declaratory of the common law. So most Bills of Rights out there are just merely declaratory of the common law. It's already the law. Once you learn that, and you know that, anything that comes in conflict with that would be void for any effect. And this word is not pronounced police. It is pronounced policy. And I can show you the etymology behind the word and some of the original constitutions from 1776, 1778. So in there, talks about policy-making powers of the legislature. Etymology of the word refers to policy, because phonetically, there's no way you can pronounce that word police. It's either police or pole ice. Like head lice or polar ice caps. Not on my watch. I've already done the research. I already know exactly how that's supposed to be pronounced. And when it came about through England creating these armed bodies of men. And that's exactly what part of our revolution was about. The Revolutionary War was these armed bodies of men that the Declaration of Independence talks about, erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance. Now, I know there's a group of certain people out there that talk about defunding the police. Well, I don't necessarily disagree with them on that particular point. And that's because I know what this word is actually, how it's supposed to be pronounced, what it really means. And this is policy-making powers, regulations to regulate foreign commerce, Article 1, Section 8, Clause 3. So, now that we know that their policies cannot come in conflict with our rights, when they do, we file a petition to the legislature to revoke their business license, and we run them out of town. That is the power of the people to maintain our general welfare, our well-being. And the public servants are supposed to sit down, shut up, and listen and do what they're told. It's called a fiduciary duty. All right. So now we will look at well, I'm going to show you the Masons first because it refers to this particular book. Like parliamentary law defined. This is chapter 6, section 35 through 39. Principles of parliamentary law talks about it comes from the common law right there. Parliamentary law is a branch of the common law. But common law stare decisis. Well, why does the 7th Amendment or Article the 7th say suits at the common law? Exceeding the value of $20, the right to a trial by a jury shall be preserved, and no fact tried by a jury shall be heard in any courts of the United States, except for pursuant to the rules of the common law. So that would be a suit at stare decisis or suits at case law? I don't think so. We're not a monarchy. That's not how we do it here. So, knowing that parliamentary practice comes from the common law, that's the law that is common to all. Understanding of parliamentary principles will simplify the learning and application of parliamentary rules. Parliamentary procedure is based primarily on a group of principles that underlie the scheme of parliamentary rules. Some of these principles are set out below. Thought of in terms of principles instead of rigid, detailed technical rules, parliamentary law is essentially logical and simple. Every deliberative body is bound to comply with all applicable rules laid down for it by the Constitution, judicial decisions thereon, and basic legal principles. Sure. These rules and principles govern whether adopted by the body or not, and they apply whenever group decisions are being made. Failure to conform to them invalidates any action taken or decision made. See how powerful this stuff is? And once you start learning this stuff and start using it, getting this knowledge, is when you start kicking the crap out of them. Now, we're going to talk about these 10 principles of the group decision making. So the first one, the group must have the authority to take the action it purports to take. Jurisdiction must be given. It cannot be assumed. Groups sometimes assume powers that they do not have. All right. So now what we're talking about here, jurisdiction. There's two types of, when we're talking types of jurisdiction, there's personal jurisdiction and there's subject matter jurisdiction. And when we go back here to the Constitution, we will look at, is it this one? Unity of subject and title. Imagine that. Every act shall embrace but one subject and matters properly connected therewith. This is called subject matter jurisdiction, which subject shall be expressed in the title. But if any subject shall be embraced in any act, enactments of the legislature, which shall not be expressed in the title, such act shall be void, only as to so much thereof as shall not be embraced in the title. Now we have to comprehend here, there's certain subjects they don't have jurisdiction over to make anything. Because remember, governments were instituted to secure these rights and receiving their just powers. So like domestic relations. No, we're in the private. That's none of your business. You cannot make any legislation regarding our rights. We're in the private. You only have personal jurisdiction over that which is in law, in the body politic, through a contract. Those of us in the private are not subject to public offenses or public law. Oh, but that's anarchy. No, we have a common law for that, which is the big body of law where things like murder, rape, kidnapping, abortion are capital offenses from the common law. Breaches of the peace, which include assault and battery. That's from the common law. That's the real law. So this correlates to subject matter jurisdiction. If the subject isn't delegated to government, they don't have jurisdiction, which means they can't make any legislation regarding it. They sometimes assume these powers. Now, in the middle of making some sort of act, it's called a remonstrance. We have the right to remonstrate, which is, hey, you can't do that because of these following reasons. A petition is actually a lawsuit. It has a prayer for relief. There's a demand. The demands are, do what you're told, do this, abolish this, alter this, revoke the business license. Now, there's two different types of petitions. You have public petitions, which affect the general public, and then you have private petition, which just affects you. Which we'll see that here in just a minute with Lex Parliamentary practice. I go over here to number 9. There must be no fraud, trickery, or deception resulting in injury to another member. Person is entitled to the protection of the courts from injury through injustice by a body making a group decision as in any other situation involving injury. Now, this is the one time where we're supposed to utilize the judicial branch under its original jurisdiction, what it was originally created for. Which is, hey, does the legislature have the authority to create that? Is that constitutional or not? That's it. Ultimately, that's what the judicial branch is there for. Otherwise, according to Article 3, Section 2, it's all under admiralty jurisdiction. Maritime. And those courts of equity have to do with land. Reading Article 3, Section 2, you will comprehend that the courts of equity are about equitable interest in the land. Very limited jurisdiction that Article 3, Section 2 lays out. Number 10, to be valid, any action or decision of a body must not violate any applicable law or constitutional provision. The decision-making procedures of any body must comply with the applicable provisions of any local, state, or federal law. It is governed by any statutory or court-made law, including provisions of constitutions and charters. So scrap the court-made law because the courts don't make law. Not here in America. Not the way our founders created our form of government, a one-of-a-kind form of government here. The reality is that court-made law, case law, only applies to the parties to the case. And unless you're a party to the case, it doesn't apply to you. That's our republic. A capitalist Confederate republic. That's our form of government. Not a representative democracy, not just a republic. Capitalism is our economy. We are a confederation, federalism, a league of friendship. That's what a union is. A league of friendship, a confederacy. And yes, we are a republic. So we are a capitalist confederate republic. It's all over in Federalist Papers. Says it at least 3 or 4 different times. Now, right in the very beginning, parliamentary law and rules. Constitutional provisions governing procedure. This is where we get into constitutional provisions stand on a higher plane than statutes and are mandatory. That's right, because Constitution is the supreme written will of the people. We dictate. Now, here it is. Powers of courts with reference to legislative procedure. All they do is provide oversight. That's about it. It's a constitutionality challenge to the statute. That's about the only power the judicial branch has in regards to the powers that are exercised in the legislature. Believe it or not, the judicial branch does not have all this power that people are using or trying to use. Now, if I can remember, I want to say it was 240. Let's try that one. I have this written down somewhere, which is at the office, of course. Thought it was section 240. Actually, I think it's part 7. Oh, I know I should have looked at this earlier. Oh, wait. Come on. I know what I need to do. Just need to go all the way back up. Now this book is a very powerful book. And just so everybody knows, in the Mason's Manual, this is written by Luther Cushings, and the Mason's Manual Legislative Procedure refers to this particular book many, 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 many times, sometimes more than 4 or 5 times on one page. And this is how I found it, was when I first got the 2010 manual. I was reading. I mean, I read through it. It took me, I don't know, 2.5 hours to read the whole book. It's not a very big book. Fits in the palm of my hand. It's not much bigger than the palm of my hand. And as you can see from the pages, there's not a whole lot on every single page. I mean, there's one page. And then you'll see here. Come on. What the heck? Right there. See? Section 1, paragraph, Cushion's Legislative Assemblies, page 990. And then there's a case there, Dye versus Mississippi, where they talked about that. Cushion's Legislative Assemblies. Cushion's Legislative Assemblies. After reading through this book, and then I got the 2020 edition, started reading through it, was like, well, you know what? I really need to go and find this book. Well, I'll be darned. This is it. This is the tool. This is the book behind all of this parliamentary practice. Let's see if I can find. Right? I thought it was right here. Now this right here will really mess you up, because not everybody's qualified to be an elector. Not everybody is able to run for office. But see, they fundamentally altered our form of government. Make it so anybody can run for office, pretty much. I think right here, mode of election, return of the persons elected, controverted returns and elections. Right here, the tribunal and mode of proceeding, of rights of membership. I know it shows in here, should say qualifying organizing of the Legislative Assembly. Imagine that. The executive branch works with the legislative branch. I swore it was like 7th. Part the 3rd. Imagine that. Even legislature has jurisdiction over civil, criminal, and jurisdiction of contempts. Should be right after this, I believe. Public bills, private bills, and judicial bills. Imagine that. What the heck was this? As you can see, there's a lot to this book. Bills of attainder, bills of pains and penalties. Yep, watch out for that one. Here we go. I knew it was chapter 7. It was 7 something. 430. And I believe there's one in here that talks. Where is it? Well, let's go down there. And I know it's going to be off a little bit, but 40 pages. Here we go. Okay, I have the right of petition. Here we go. We finally get here. So I apologize for that. It's a lot to try and remember where everything's at. Come on. Oh, of course. You want to do that. Yeah. Well, hopefully everybody can see that. It is chiefly by means of petitions that the people in their character of constituents are brought into communication with the two houses of Parliament. See, it's the two houses of Parliament, and especially with the House of Commons as their representatives, so far as the legislative body is elective, so far that the constituents, by their votes for particular candidates, express their opinion of public measures and policy. In certain cases also, as a certain extent for the particular purposes, they have the power to instruct their representatives. But neither of these modes of communication is adequate to all the occasions on which it is desirable that the wishes of constituents should be made known to their representatives. Petitions alone enable constituents to retort to the representative body. Whenever in the judgment of any one or more of them, it is necessary or proper to do so, with reference to any matter, either of a public or private nature, which is within the jurisdiction and functions of the legislature. A petition is an instrument in writing addressed by one or more individuals to some public tribunal, that would be that court of justice, or authority, in which on the ground of certain facts therein set forth, the petitioners request the official interference of such tribunal or authority, either for the particular advantage of the petitioners or for the correction of some public grievance. This is what the right of petition is about. Okay? So when the object of a petition is particular benefit of the petitioner, it's a private petition. When it is for the redress of some public grievance in which the petitioner has no particular or individual concern, the petition is a public one. Well, it can be, you could have a particular concern, like election fraud. So in both cases, a petition may emanate from a single individual, or it may be the act of as many persons as have a common interest in the subject and are willing to unite together for the purpose of prosecuting it. Whoa, wait a minute. That's right. We become the prosecutors. This is a power properly belonging and retained by the people. When we say attorney, that's prosecuting attorney, and we have the right to prosecute our own claims. That right happens to be enumerated in Wisconsin Constitution, Article 1, Section 20. We all have the right to prosecute our own claims, or you can elect somebody else to do it on your behalf. But an attorney has nothing to do with the bar. A lawyer, defense lawyer, one who is knowledgeable on the law, one who speaks the law, is a law sayer. That's a defense lawyer. So we have the defense and the offense. And again, has nothing to do with the bar. It's about whether you're the moving party or the defending party. Or there may be as many separate petitions relating to the same subject as there are individuals. Or there may be several similar petitions, each signed by several persons. Now we got key words here. Persons. Come on. All right. The right of subjects to petition their rulers for a redress of grievances, either public or private, is acknowledged as a fundamental principle of the English Constitution and has been uninterruptedly exercised from the earliest periods. Now, see, this covers the whole history of the right. And we'll see, it gets in here and it starts talking about the American law. But this is, again, a full, this is the book. And has been uninterruptedly exercised from the earliest periods. The right to address the two houses of Parliament in this manner is coeval with their existence. So, you have the right to petition, you have the right to remonstrate, and you have the right to address. So the petition is a political lawsuit to prosecute your own claims. Remonstrant is in the middle of them making some sort of policy. Those bills are pushing through. You file a remonstrance. The right to address has to do with going in, literally doing that 2 or 3 minutes, and talking to the committee or even the whole body. This is a right and power retained by the people. But if you're going to do this stuff, you have to know the proper language. You have to use decorum. And your paperwork has to be proper. So the right to address the two houses applied to themselves, to the House of Commons, who are more immediate representatives of the people, have always, in the forcible language of Mr. Speaker Abbott, opened their doors wide for receiving the petitions of all His Majesty's subjects with respect to grievances, whether real or imaginary. This right rests on no written charter like that of petitioning the Crown, but as was said by Mr. Fox, no man could question the subject's right to present petitions to their representatives, because it was idle to suppose that when a stipulation had been made by the Bill of Rights that the subject should, in all cases, have a right to petition the Crown, they had not an equal right to petition the House of Commons. Okay, this is the English Bill of Rights, 1689. Their own representatives. The right of petition is stated in the following terms by Mr. Hatzel: to receive and hear and consider the petitions of their fellow subjects, when presented decently and containing no matter intentionally offensive to the House, is a duty incumbent on them, and to send it to all rules and orders that may have been instituted for their own convenience. Justice and the laws of their country demand it from them. That's this 3 here. As to the right to petition in general, see also the speech on Honorable Robert C. Winthrop in the House of Representatives in the United States on the 23rd and 24th of January of 1844. So this is that court of justice. There could be no doubt that in this country the right of petition is as sacred and as well established as it is in England, even where it is not secured by constitutional provisions. But in all the American constitutions, except those of the states of Virginia, North Carolina, South Carolina, Georgia, and Louisiana, it is secured in the amplest manner, usually in the following terms, contained in the Constitution of Florida, namely, the people have a right in a peaceable manner to assemble together to consult for their common good, and to apply to those invested with the powers of government for redress of grievances, or other proper purposes by petition, address, or remonstrance. That's the Florida Constitution, which happens to be where Christopher Hallett was out of. And again, he was recently murdered there November 15th, 2020, due to what we were filing. It is with respect to the measures of public character that the right to petition has been deemed the most sacred and has been guarded with the most care, as it is by this means only, pay attention, by this means only that constituents can express their opinions upon great national questions and bring their opinions to bear directly upon the legislative power. Only. That's how our form of government works. So all this crap of trying to figure out what to do in the judicial branch, when we don't even know this particular right, how this right works, and how our form of government is supposed to work, you're going to lose, because that's what they put themselves there for in the judicial branch. Call them gatekeepers. They don't want to allow this stuff to happen, right? If you got enough money, you can pay some people off. You might be able to get through. But some of the bigger things, Sidney Powell, they already went to the Supreme Court, and the Supreme Court said we don't have jurisdiction. Imagine that. The Supreme Court actually told them. I put it out on my show before. When that first came out, I said, yeah, duh. Judicial branch doesn't have subject matter jurisdiction. So, let's get down here real quick, because this lays out, everything that you need to know is right here in this book. Well, I wouldn't say everything. There's a couple things. Let's see. In a petition, the statements of the petitioners are received as the ground of the prayer for which they make. A memorial, which is similar in its statements and allegations to a petition, but is unaccompanied by a prayer. So, like motion practice, it has a prayer for relief. That's where we make our demands. Literally, the word demand is in there. Is said to be objectionable to the point of form, because it assumes to speak as an equal and to advise the legislature as to its duties without any particular object in view. But such papers have nevertheless been received as petitions when there was no other objection to them but in point of form, and they contain language equivalent to a prayer. So if you got some sort of demand in there, you want them to do this and you want this relief, they still have to consider it as a petition. Now, a remonstrance, which may be regarded as a similar representation, unaccompanied by a prayer, and intended to express opposition to the passing of some act, or the adoption of some pending or contemplated measure, is equally objectionable in point of form and for the same reasons. So some of this stuff can be objected to if it's not in proper form. Papers with this title, when drawn up in respectful language and amounting substantially to a petition against some proposed or pending measure, have been received as petitions. But in general, it appears to be the usage, especially when the object is to call in question the proceedings of the House, to reject papers on this description. A protest is similar in character to a remonstrance, but expressed in stronger language. A declaration against any measure does not seem to be different from a protest or a remonstrance. Papers bearing any of these titles, if they contain a prayer, are received as petitions. It may be observed in general that the objections to remonstrances, protests, etc., are, for the most part, merely formal. So, format. The same statements which they contain may be put into the form of petitions and are then receivable. Paper expressing approbation of the proceedings of the House is equally objectionable with a protest or remonstrance, and is not receivable unless it bears the form of a petition. So you really got to kind of know what you're doing here in order to succeed, to get past the gatekeepers. The right of petition is not subject to any of the formal or technical rules as to parties by which the proceedings in courts of law are governed. Imagine that. Courts of law are governed. All persons of whatever condition and under whatever circumstances, married women, infants, aliens, may petition, provided only that they have sufficient understanding to know what they are doing. That's what I'm here for right now, is trying to give you a basis. Try to give you that sufficient understanding to know what you're doing here. so that we can prevail. They have not understanding enough to act for themselves, their guardians, if they have any, or their friends, if they have no guardians, may petition for them. So, want to be pioneers in this? You want to learn this? You want to actually win? Do you want to fight or do you want to win? Because this is where we're going to win. Because this is where we start claiming our powers. We instruct our representatives to alter, reform, or abolish anything at any time we deem it necessary. And it only takes one. One petition, one man, one woman. It does not take 100,000 signatures to do a petition. That's a lie. And we can do this on behalf of others. All right, so we're going to get down here and it talks about the different parts of a petition. Come on. All right. Of petitions as to their form. The several subjects which require to be noticed with reference to the form of a petition relate first to the material substance upon which and the manner in which a petition is drawn up. Who would think that the material that this is drawn up on would have anything to do with filing a petition being in proper form? Second, to the different parts of a petition, namely this that should be subscription or direction, and the designation of the parties, the general allegation, and the prayer. Now that's what I call the body. Third, to the signing, the signatories. Fourth, to the matters extraneous or annexed to the petition. That is your evidence. So just like this applies pretty much to every single document, whether it's judicial branch, executive branch, legislative branch. It's called the caption portion of a document. Who it is addressed to. Now let me see if I can pull up boy, where in the heck do I have this? Should be in. Where in the heck is it? Let's see if this is the right one. Do we got going on here? Yes. Oh, nope. Well, it's one that I've done before. I'll show you this one real quick. And I'll try and find the other one. This is called diploma font. The beginning of it should be written in diploma font. Now, back when we first started this stuff, we didn't know the difference between a petition, that there was a difference between a petition and a remonstrance. So we called it a petition of remonstrance. I discovered this Luther Cushing's book and then discovered that it was, there's a difference between a petition and a remonstrance. But I've done all the research here in Idaho already to file petitions. And this was a document template that we used to show people. And look, there's us E-Clause back in the day. 10 principles of government procedure, Knowing what I know now and what I just read there, this is not at all in proper form. but it has worked. This is one I started putting together to go after these unlawfully created agencies. I wish I could find the one. One that I've gotten done proper. Oh, wait. Nope. Dang it. I doubt this one's in it. Nope. Yeah. So there's these different parts, and it basically the caption portion, which that's what that was. This is the caption portion of a document. Who it's to, basically the jurisdiction, and who the parties are in this particular format. Now, in court cases, you'll recognize some of these things. They might be organized different, but this is pretty much the caption portion of a document applies to everything. Every single document, depending on where you're at, changes. But this caption portion is always there. Who it's to, what the title of the document is, who the parties are, and the jurisdiction. Will always, sometimes the case number. Sometimes they'll have a case number there too. We don't use case numbers in the legislature. So this is something to apply to everything you do. Criminal complaints, all of it. This has that caption portion. And then you have what's called the body, which this is not a very good example to use right now. And I do have one that I've been working on that's in proper form, but seems to behoove me where it's at right now because I got a lot of stuff. Come on. Just close, would you please? Let's go with document templates. I swore oh, wait. I bet it's here. Nope. Dang it. Well, I'll have to share that at a later date. But these are the different parts of it, how it's laid out. So the material required for this purpose is either parchment or paper, on the one or more skins or sheets of which, but if the latter, they must be so joined together as to form one whole. The petition must be written in the English language, or, if any other, it must be accompanied with a translation, which the member presenting it states to be correct. This rule is one which, of course, admits of occasional relaxation, but whether in those states where the language spoken by a portion of the inhabitants is not English, and where the laws or legal proceedings are published in 2 or more languages, it is applicable, may admit of some question. So, realizing how old some of this parts of this right is, back to parchment paper. Let's see. In the Commons, it is an established rule that a petition must be written and not printed or lithographed. Now, what they're actually talking about there is cursive writing. When it says to be written and not printed, the difference between cursive and print. Previous to the year 1656, it appears to have been allowable either to present petitions in a printed form to the committee, who were then generally authorized to receive them, or for petitioners to cause their petition immediately upon being presented to be printed and distributed among the members of the committee. In that year, an order was made that no private petition should be printed before being presented to the House. Now, in that particular sense, they are talking about copied, right? But yes, it is to be written in cursive. Whether this order was deemed to be enforced or not after the dissolution of the Parliament at which it was made does not appear, but it seems certain that it soon became the established practice of the House of Commons to decline receiving any petition, either private or public, which was in a printed form. See how stickler these things can be? And such is understood to be the established rule at the present time. The House of Lords, though the rule seems to be the same, it has not been so strictly observed. A printed petition in favor of the Catholic claims being received in 1813, but not to be drawn into precedents. Okay, a petition must also be free from erasures and interlineations on the ground that where any such alteration appears on the face of the petition and is not explained, it is a circumstance of so equivocal of a character that in point of form the petition can no longer be considered as that of the persons by whom it is signed. I know, crazy little rules and, sticklers. But this is some serious stuff. But this circumstance is susceptible of explanation. And so you can do all those little markings in there and put your initials by it. But it's best not to have any kind of erasures or corrections. You just do it right. And if you do it wrong, you redo it until you get it right. And if it appears that the alteration was made by the petitioners themselves or with their knowledge and consent, the member presenting the petition so stating the fact to be, such petition is to be regarded as that of the signers and may be received. Okay. As to the several parts of the petition, petitions are to be addressed to the House in which they are to be presented. If to the House of Lords, the form is to the Right Honorable Lord Spiritual Temporal Parliament. See how it's supposed to be addressed? To the Honorable the Commons of Knights and Citizens of the United Kingdom of Great Britain and Ireland and Parliamentary Assembled, and any essential variation from this form as to the address of petition. To the Upper House, Okay? So we have it a little bit different here in America, right? The second part of the petition is its title under the designation which the petitioners give it and to themselves, which should be in this form. The humble petition of, this is where I got this in mind. My drafted one, which I wish I could find. I'd show it to you. The humble petition of, and put our names there, right? Being here inserted, humbly sheweth that these facts be submitted to a candid world here. Here's your statement of facts. It is irregular for the parties to entitle their proceeding a remonstrance or protest or memorial alone, because it can only be received as a petition. But it is not fatal to do so, because if the paper contains the other requisites of a petition, it may be received as such. But we can forget all about that if we just go in knowing what we're already supposed to do and it's in the proper format, then we don't have to worry about this. So it is also irregular to entitle the paper the petition, merely omitting the word humble, or to use the terms respectfully sheweth instead of humbly sheweth. And this irregularly has, for the most part, but not always, made it necessary to withdraw the petition. In regard to the designation of the parties, if there is but a single petitioner or some few only, the name and edition of each are usually given. If the parties are numerous, they commonly describe themselves in general terms as inhabitants, freeholders, silk manufacturers and throsters, parishioners, resident householders, workmen, I think is what it is, workmen. Yeah, workmen, members of a lodge or odd fellows or of a political or other union of a particular place. You know, it's pretty crazy how all this stuff applies right here. How you even put your name on there. If petitioners give themselves a designation to which they are not entitled, this is an irregularity on account of which it may be necessary to withdraw the petition. So you got to be real careful what you put in there. What's your status here? Because this has to do with status and standing to claim a right to a cause of action. What kind of person are you? Are you a man, a woman, or do you have actual personage, such as an Idaho notary public, like me? Are you an owner of some sort of business? Those are in my proper person. So like in my proper person as owner of Kirk's Law Corner LLC. In my proper person as notary public for the state of Idaho. Those two personificances or personalities, persons, are all fictions. They're all shmoo, stuff made up. It's all created on paper. A man is a creation of God. That is a given. We're among the living, not a person. So, the third part of the petition, the body of it contains the general allegations or statements upon which the petitioners ask the interference of Parliament. This part will be considered more particular hereinafter when treating of petitions as to their substance, subject matter. At present, one circumstance only will be alluded to. So when we do an election petition, that's what it is. It's an election petition. And then you do your statement of facts. And then you do your prayer for relief. And I'll show you a little from the courts. This is the treatise on arrest and false imprisonment, by the way. Come on. Now this particular book is a very good read, and you can get this on kirkslawcorner.com. Go to the library, Treatise on Arrest and False Imprisonment. This is one of the most powerful books you'll ever read. This lays the smackdown like nobody's business. I highly recommend everyone read this book. It has the document templates in it right here for complaints. Now, perfect example again. Caption portion of the document. This is the caption portion of the document. Who it's to, who the parties are, case number, the title of the document. This is the body of the document. Come on. It's being goofy. Now, this is a summons, by the way. Come on, jeez. Okay, so this is in the form of a complaint. Plaintiff for his complaint against defendant, okay. This is a statement of facts, and it's based on the 4 W's, so this is also going to basically cross-pollinate here with criminal complaints and a petition, because it's It's all the same. It's in the form of an affidavit. This is how we do this. The 4 W's. Who did what, where, and when. Those are the 4 things that need to be articulated in the statement of facts. So, on this date, plaintiff, well, the plaintiff's name is up here, was traveling in his automobile. So, this is the when. On the public highway, where? Ridgefield in Minneapolis, going northbound, and highway patrolman. So there's another who, an employee of the state of Minnesota. The defendant asked plaintiff to see his driver's license. Now we're talking about the what. What was the conduct? The plaintiff explained that he is not a licensee, So you get an idea of these short, clear, concise statements of facts. No fluff, less is more. Now, what I tell people on certain things, whether you're doing a court case, whether you're doing an election fraud, whatever, keep your statements short. If you have to, write it all out. Write the whole story. Then go back through and break it down into individual statements and start getting rid of the fluff. Because nobody wants to read a book when they're wanting to look at your statements of facts. On this day, the sun came up at this time over here where I was at. I mean, it's simple, very simple. But it is the hardest part to do. In my mind and everything that I've done, writing the statements of facts is the hardest part to do. But once you get it down and you start learning how to do it, it becomes easier. Now see how short, clear, concise these statements of facts are. And now when we talk about going in for like tort claims or criminal complaints here, plaintiff realleges paragraphs 1 through 7. This is count 1, false imprisonment. Count 2, false imprisonment. Now notice, on September 30th, the defendant without warrant or due process of law, Minnesota Constitution, Article 1, Section 7, unlawfully arrested the plaintiff and, acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. I don't see any Minnesota code here. I don't see Minnesota statutes here. That's because it's the right is the law. Rights are the law, not code. Same thing again. The defendant realleging 1 through 7. Minnesota Constitution, Article 1, Section 2. Okay. Oh, look at that. Assault and battery. We don't need the Constitution for that because that's the common law. It's already the law. I don't need any code. Everybody's supposed to know this by self-evident. Should be self-evident. And then in this particular book, here's the memorandum of law. Got a document template already here. Okay? So, your statement of facts is who did what, where, and when. The 4 W's. And the evidence to support it. Okay? Usually we gather the evidence first, and you put the evidence in a chronological order of things, by date, and it'll tell you right on the paperwork who wrote it, on what day, what it is, and what they did. You pull that right straight from your evidence, and then you cite that in your statement of facts. See Exhibit 1, Exhibit 2, or Exhibit A, Exhibit B, depending on who you are and what you're doing. Usually the moving party uses ABC, and the defendants uses 1, 2, and 3. So pretty much that's the gist of it right there. We get down here to your prayer for relief, in which the last part of the petition is the prayer in which the particular object of the petitioner is expressed. What do you want him to do? This is essential in point of form to constitute a petition, and without it, a document cannot be received in that character. A paper containing statements of facts, however important, or arguments on any document, however admirable they may be, is not entitled to the consideration of the House unless the petitioner has some object in view further than the mere communication of information. The prayer also must be for something to be done or omitted by the House in the way of its ordinary proceeding as a legislative body. It is not a proper prayer for the petitioner merely to ask the attention of the House to his statements. So you have to put in your demand for relief. It's called prayer for relief, and petitioner demands the following. I don't know. Let's use the election audit because that's where we're here. Part of it is that we demand we demand an investigation and a complete forensic audit of the entire record. An election audit. Now, I could have swore that election petition itself was right here, right before this petition, and maybe it was after. But it should be right here, one way or the other. There is actually an election petition in this book. And I want to say it was right before it, but it might have been after. I mean, there's definitely more reading here to be read, but that's the gist of it. Getting your petition done, and whatever it is that you want to petition, whether it's a private petition for you yourself or a public petition. This is how we're supposed to do it. This is where it goes, is to the legislature. And by the way, it goes to, there's a clerk, just like a clerk of the court in the judicial branch. There's a clerk of the House and a clerk of the Senate. You file it with the clerk. And the clerk is supposed to distribute it. But the key is we have the right to present our own petitions. It's in this Mason's Manual of Legislative Procedure here. Petitioners have the right to present their own petitions. I think it's section 10 or part 10. Should be right here. 7:30. I know that's it. Oh, we're be. Anyway, it says in here that petitioners have the right to present their own petitions. So they try to tell you you don't have that. Oh, yes, that's a right and power retained by the people. We don't seek permission from our servants to exercise a right. Okay.